Hello everyone and welcome to the June 2026 edition of Michigan PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Robert Carr. Today's topics first include our usual most recent case law updates. First case law update is on the unpublished opinion per curiam of the Court of Appeals that was issued on May 18, 2026, called Michigan Ambulatory Surgical Center and Phase 1 Rehab versus Progressive Marathon Insurance Company. The second case we will discuss is a published decision per curiam of the Court of Appeals that was issued on June 11, 2026, called Zielinski versus Auto Owners Company, number 3716692, 2026, WL1699526 at Section 1, Michigan Court of Appeals, June 11, 2026. Lastly, we will focus our discussion on the trending topic of PIP litigation pertaining to two recent cases, one published and one unpublished, in which the Court of Appeals upheld appeals after PIP settlements resolved by stipulated order. The first case we'll discuss is the unpublished opinion per curiam of the Court of Appeals that was issued on May 18, 2026, called Michigan Ambulatory Surgical Center and Phase 1 Rehab versus Progressive Marathon Insurance Company. This case reiterates that any disputing information, including contradictory testimony, can allow a court to find a question of fact regarding order of priority when it comes to domicile, even when the injured party's first-party case is dismissed for lack of priority. Plaintiffs Michigan Ambulatory Surgical Center and Phase 1 Rehab, as assignees of patient Jamarisha Campbell, filed suit in Macomb County Circuit Court seeking PIP benefits from Progressive under the No-Fault Act. Progressive moved for summary disposition under MCR 2.116C10, arguing Campbell was neither a named insured nor a resident relative under the subject policy. The trial court granted summary disposition in Progressive's favor. The Court of Appeals reversed and remanded with one judge dissenting. The details are that Campbell was injured in a July 2021 motor vehicle accident. She was not a named insured on the Progressive policy, but claimed coverage as a resident relative of the named insured, Cindy Wells, Campbell's daughter, under MCL 500.31141. Defendant Progressive conducted recorded statements and depositions with both Wells and Campbell. Progressive raised the following arguments to show that Wells' domicile should be considered Birmingham, not Redford. These are the arguments. The policy was issued in Wells' name, listed a Redford address, and reflected two household residents. Wells testified she lived with her husband after marrying and moved to Birmingham before the accident. Wells testified she had no dedicated bedroom at Redford and was sleeping in her mother's room when she visited. Wells stated she was no longer responsible for rent at Redford. In its MSD, defendant raised Ford versus Trinity Health Corp. 495 Michigan 8069 2013, where the plaintiff's testimony was blatantly contradicted by multiple independent, consistent pieces of documentary evidence, including emails, affidavits, and third-party testimony, predating the litigation. Using the case, defendant had already been granted a motion for summary disposition in Campbell's own first-party case on the domicile question. However, plaintiff in this case held that a question of fact existed as to the Wells domicile. Plaintiff pointed out that Campbell also testified under oath that Wells lived with her at the Redford address at the time of the accident. Wells further testified she kept belongings at Redford, such as everything from a toothbrush to clothing, pajamas, everything. Wells received mail at Redford, and Wells continued to stay at Redford, shuttling between those addresses. Further, Wells' driver's license address at the time of the accident was the Redford address, and the Progressive policy was issued with the Redford address. Under MCL 500.31141, a no-fault policy covers a relative of either domiciled in the same household. Domicile is defined as the place where a person has voluntarily fixed his abode, with a present intention of making it his home, either permanently or for an indefinite or unlimited length of time. That's the Grange insurance case. No person can have more than one such domicile at the same time. That's also the Grange case. Generally, the determination of domicile is a question of fact. That's the Fowler versus Auto Club case. However, when the underlying facts are not in dispute, domicile is a question of law for the court. So in MSDs, as we know, domicile is generally a question of fact, subject to a multi-factor analysis drawn from the Workman v. Detroit case, including subjective declared intent to remain, formality of the household relationship, physical co-location, and existence of another place of lodging. Now, adult children of an insured who may have complicated living arrangements because they still might keep their old address. That's from the Grange case. And as such, courts may also consider the related factors identified in the Dairyland Insurance Company versus Auto Insurance case, including whether the claimant continues to use his parents' home as his mailing address, whether he maintains some possessions with his parents, whether he uses his parents' address on his driver's license or other documents, whether a room is maintained for the claimant at the parents' home, and whether the claimant is dependent upon the parents for support. That's the Dairyland case. The Court of Appeals was split on this 2-1 ruling, with Justices Randy Wallace and Christina Garrett reversing the trial court's granted MSD due to genuine issues of material fact regarding domicile. The ruling opinion pointed out that the Furr case did not apply here because defendants solely relied on the testimony of Wells and Campbell, which itself was contradictory as to which domicile Wells had at the time of the accident. Further, as opposed to the Furr case, there's multiple other proofs besides testimony, including the insurance policy, Wells' driver's license post-marriage, and Wells' own contradictory deposition, and her continued ties to Redford. Ultimately, the ruling found that the trial court made credibility determinations, accepting portions of Wells' deposition and rejecting Campbell's testimony as quote-unquote self-serving, which is impermissible on a C-10 motion. That's from the White versus Taylor case. Domicile disputes are fact-intensive and credibility-driven. The Furr case blatant contradiction doctrine has a high threshold. Insurers attempting to dismiss a claimant's testimony as self-serving need multiple independent, consistent documentary or testimonial items to meet that bar. A single deponent's internally conflicting testimony won't carry it. When pursuing a domicile defense, develop the record beyond one witness. Additional evidence, utility bills, lease agreements, bank records, cell phone location data is essential to reach the Furr threshold. Lastly, even the granted MSD in the claimant's circuit court matter was not considered by the trial court in this matter because the medical provider plaintiffs were not parties to that proceeding. A reminder that parallel PIP litigation by different plaintiffs on the same underlying claim does not automatically bind all parties. The second case we will discuss is the published decision per curiam of the Court of Appeals that was issued on June 11, 2026, called Carrie Lynn Zielinski versus Auto Owners Insurance Company. Now, this case has a number of holdings. The main holding for PIP concerns an insurer's unreasonable delay in payment, leading to $288,000 in attorney fees awarded to plaintiff. In January 2021, plaintiff Carrie Lynn Zielinski was rear-ended at a red light by Charles Watkins, whose vehicle struck plaintiff's car with enough force to push it into the vehicle ahead. Plaintiff also had a significant pre-accident medical history, including 19 prior spinal surgeries. Treating surgeon Dr. Elia opined that plaintiff's cervical myelopathy and need for a February 2022 neck surgery were causally related to the accident, and that a subsequent October 23 lumbar surgery was necessitated by the biomechanical consequences of the first surgery. Auto owners received the neck surgery bill in April of 2022. In July 2022, however, it wrote to Medicare acknowledging that plaintiff had injured her neck in the accident and was treated for that injury. Auto owners then arranged a records-only IME with Dr. Kalkanis, which concluded in October 2022, 3 months after the Medicare letter, that plaintiff had suffered no spinal injury from the accident. Auto owners denied all surgical bills in November 2022. Now, plaintiff Zielinski brought a no-fault PIP action against her insurer, Auto Owners, for unpaid benefits related to spinal surgery. Plaintiff also brought a negligence case against the at-fault driver, but that was settled prior to the trial. Following a 2-day jury trial, the jury found in plaintiff's favor on the neck surgery bill, but against her on the subsequent back surgery bill. The trial court awarded $315,605 in total compromising overdue benefits, prejudgment interest, penalty interest, taxable costs, and including $288,000 in attorney fees. Auto owners appealed on 3 grounds. The Court of Appeals affirmed on all 3 issues. So, defendant Auto Owners' first issue was a motion for a new trial, as plaintiff counsel had referred to the at-fault driver being drunk during the cross-examination and the closing argument. Plaintiff counsel stated twice in closing argument that plaintiff was rear-ended at 45 miles an hour by a drunk driver. Now, the court denied defendant's motion, acknowledging that referring to at-fault driver's intoxication was irrelevant, constituting error, but the error was harmless and there was no prejudice to defendant. Further, defendant never objected at trial and only raised the issue for the first time in its motion. Second, and the main part we're talking about here, defendant opposed the attorney fees award, stating that it had reasonably denied the bills due to its investigation and also its IME. The No Fault Act provides for penalty interest and attorney fees when an insurer unreasonably refuses to make timely benefits payments. That's MCL 500-31422 and 4 and MCL 500-31481. The penalty interest and attorney fees provisions create an axiom under the No Fault Act that insurers must pay PIP benefits to claimants promptly and sort out priority and reimbursement issues later. That's the Esurance case from 2021. That axiom is actualized by the very real possibility that steep penalties will be assessed against an insurer that drags its feet in paying PIP benefits to claimants. That's also from the Esurance case. An attorney is entitled to a reasonable fee for advising and representing a claimant in action for personal or property protection insurance benefits that are overdue. Benefits are overdue if not paid within 30 days after an insurer receives reasonable proof of the fact and of the amount of loss sustained. That's from MCL 500-31422. MCL 500-31481 establishes two prerequisites for the award of attorney fees. That's from the Moore versus Secura case. First, benefits must be overdue under 500-3142, and second, in post-judgment proceedings, the trial court must find that the insurer unreasonably refused to pay the claim or unreasonably delayed in making proper payment. That's also from the Moore case, quoting 500-3148. Now, an insurer can show its delay was reasonable by showing that the refusal or delay is the product of a legitimate question of statutory construction, constitutional law, or factual uncertainty. That's from the Ross versus Auto Club case, 2008. Further, the delay can be deemed reasonable even though it is later determined that the insurer was required to pay these benefits. That's from the Moore case. The determinative factor is not whether the insurer ultimately is held responsible for benefits, but whether its initial refusal to pay was unreasonable. In this case, the court ruled the defendant failed to rebut the presumption of unreasonableness. Defendant cannot claim legitimate uncertainty when its own contemporaneous documents contradict that position. Specifically, defendant had received the surgical bill in April 2022. By July 2022, it had written to Medicare affirmatively acknowledging the causal link between the accident and the plaintiff's neck injury. Further, the October 2022 Calcanus IME, conducted 3 months after defendant's own concessions of causation, could not retroactively manufacture a factual uncertainty that did not exist as of July 2022. Lastly, defendant fought the high cost of plaintiff's fees, including $750 per hour for the lead attorney, and that the hours submitted by plaintiff were not tracked contemporaneously, but instead were added up after the trial. However, the court ruled that though the case included only a $50,000 PIP cap and required just a 2-day trial, the issues were complex and the risks were high of non-recovery. Further, a full evidentiary hearing was held with affidavits, testimony, invoices, and spreadsheets as evidence. While the court struck duplicative hours, it awarded plaintiff most of its fees requested, as there is no Michigan authority for contemporaneous timekeeping. We want to now focus our discussion on the trending topic of PIP litigation pertaining to 2 recent cases, one published and one unpublished, in which the Court of Appeals upheld appeals after PIP settlements were resolved by stipulated order. The cases are Stanley versus Farmers Insurance Exchange, number 374881-2026. That's Westlaw 1674086 at 1. Michigan Court of Appeals, June 9, 2026. And Saad, Yousif, Ishoo, and Marena, Saad, Ishoo versus Farm Bureau General Insurance Company of Michigan, decided May 21, 2026, unpublished. In both cases, plaintiff lost a partial MSD, but continued their matters until a PIP settlement was reached and a Stip order to dismiss was filed. Significantly, both Stip orders preserved no rights to appeal the MSD rulings. Plaintiffs then appealed the MSD rulings. In both cases, the court dismissed the appeals for lack of jurisdiction. So the Ishoo case, plaintiffs sought uninsured motorists and underinsured motorists and PIP benefits from Farm Bureau following a hit-and-run accident. The policy required for UM/UIM claims that plaintiffs permit inspection of the vehicle within 15 days of the accident and that plaintiffs submit to an examination under oath as requested. However, plaintiff didn't keep the car and ignored the request for inspection and also ignored the request for an EUO, instead filing the lawsuit. Defendant moved for partial summary disposition under 2.116 on the UM/UIM claims, arguing the cooperation clause violations precluded the suit. The trial court agreed and dismissed partially the UM/UIM claims. The parties, after some time of negotiation, then stipulated to dismiss the remaining PIP claims with prejudice without any reservation of appellate rights. Plaintiffs appealed, seeking to challenge the earlier UM/UIM dismissal. So in the Stanley case, plaintiffs sought PIP benefits from both auto owners and MAIPF farmers after a December 27, 2021 head-on accident. First, the parties stipulated to let out auto owners MAIPF, then filed a partial MSD, arguing that plaintiff could not recover certain medical expenses because she had assigned her rights to the medical providers. Plaintiff said that the assignments were invalid, but the trial court agreed with farmers that the assignment was legitimate and that the providers' bills be stricken. The parties then later entered into a stipulated order dismissing the remaining claims with prejudice. In Stanley, the court noted that stipulated orders are construed under contract principles because they are agreements reached by and between the parties. That's the Spires v. Bergman case. Accordingly, when a party expressly reserves the right to appeal a prior ruling and a stipulated dismissal, that reservation may be enforced. See Travelers Insurance v. Newry and Cassenda v. Archdiocese of Detroit. Conversely, where a party agrees to a final dismissal with the same opposing party and fails to reserve appellate rights, the stipulated dismissal extinguishes any claim of appeal from earlier rulings involving that party. That's from the Dora v. Zielinski case and the Bagan v. Michigan Bell Telephone Company, as well as the Cassenda case. So in both Ishoo and Stanley, the Court of Appeals also analyzed the Jaber v. P&P Hospitality LLC case, also known as Jaber 2, from 2024. In that matter, however, the court held that a plaintiff could appeal an earlier order dismissing claims against Party A because the final stipulated order involved only claims against Party B. The Jaber 2 court's rationale is that a non-party to a stipulated order should not be able to dictate that a plaintiff was required to include an appellate reservation to that agreement. However, in both Ishoo and Stanley, the stipulated dismissal involved the same parties as the earlier adverse order. The general rule is that parties who consent to a final order ordinarily cannot appeal its merits. Stipulated orders are construed under contract principles. Plaintiffs, having consented to dismiss all claims of prejudice and having failed to carve out any appellate reservation, surrendered their right to challenge any of those claims on appeal. Although a party may preserve the right to challenge an earlier interlocutory ruling and a stipulated dismissal, the stipulated orders here contain no such reservation. Under these circumstances, plaintiff was required to preserve any appellate challenge to the earlier ruling in the stipulated dismissal. Because plaintiff failed to do this case falls squarely outside the circumstances in which appellate review may be preserved following a stipulated dismissal. That concludes the June 2026 edition of Michigan PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to Robert Carr or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.